Good afternoon. This is on the matter of People versus Shane Evans, People versus Shandon Groom, and People versus Timothy Moore. On behalf of the people.
Victoria Shackelford Ford on behalf of the people.
And on behalf of Mr. Moore.
Christina Joseph appearing on behalf of Mr. Moore.
And on behalf of Mr. Groom.
David I. Goldstein appearing on behalf of that defendant, Your Honor.
And on behalf of Mr. Evans.
Cora Watt appearing on behalf of Mr. Evans, Your Honor.
This matter was set today. I know that we have an adjourned PCC on February the 10th. This matter was set for today for some housekeeping issues, and then Ms. Watt filed her motion, her objection to the protective order on the discovery. And so before we get to the other housekeeping issues, I'm going to hear that objection. I guess it's technically, Ms. Shackelford, it's your motion. It's your motion for the discovery order. So if you want to go ahead.
Thank you. Your Honor, people make this motion pursuant to MCR 62.01E. The people are requesting a protective order on the paper and electronic discovery in this matter to preclude the dissemination of the discovery to third parties. In this case, Your Honor, I do believe there's good cause for the protective order. I've laid out some of those issues in my motion. Ms. Watt and I did have conversations, and we did make attempts to resolve this without the court's intervention, but I just don't, I mean, we're basically at a standstill at this point. This is an ongoing investigation. As the court's aware, there are other people of interest who have not been taken into custody or charged at this point and are currently under investigation. Disclosing the nature of the investigation to third parties would certainly be disruptive to the investigation. And Judge, I would just also indicate that Ms. Watt, and I know Your Honor wasn't present at our last hearing, it was
Judge Martin.
Thank you. Judge Martin. And Ms. Watt's disagreement, it's my understanding, was that she wanted to be able to read reports to defendant's mother. And my concern with that, and if the court's not aware, is these three individuals are related to each other. All three defendants have some sort of familial relationship between them, stepbrothers, cousins, things of that nature. So obviously disclosing, reading the reports to other family members certainly would be problematic for the investigation. And Judge, I would just also indicate that a lot of the information contained in the discovery, this was a 3-year case. It's been going on for almost 4 years now. There are phone extractions, third-party social media, search warrant returns of people that aren't even, part of this case. So, protecting their, information is certainly important to the people. So I think given all of that and the intense media attention that this case has already received, and I would anticipate will continue to receive, I think there is good cause and that protective order should be issued.
Ms. Watt?
Your Honor, I think there's been a misunderstanding because as I put in my objection, it was never my intention to disseminate written or digital discovery to third parties. I've never done that in my entire career because I think that's malpractice. So what I was referring to was being able to discuss certain aspects of the case with the defendant's family member. And I guess one of my major objections was that, the way that it's like a blanket protective order. And without us, there are a lot of ways to issue a protective order. Certainly, I have no objection to not disclosing information that would divulge the identity of witnesses or, people that are being investigated. What I'm objecting to is a blanket prohibition to me even being able to discuss the facts of this case that might be in an investigator's report, the facts of the case with the defendant's family member, I think is overbroad. I don't think that there's been anything that's been placed on the record that would indicate that the court would need to put something in place that is that overbroad. I would also argue that we don't even know what these items are, because I know the court hasn't seen any discovery. I haven't seen any discovery. I don't even have an investigator's report. So for me to agree to, this protective order, I don't have any discovery. And as I've indicated, the court could have certainly allowed me to get the discovery and done some type of temporary order, and we probably could have come to an agreement on what things should not be released. I'm not trying to be unreasonable, but
No, and I don't think you are. I think that part of the problem is, and I agree with Ms. Shackelford, and it's mentioned in her motion, is that in order for them to redact, if there's no protective order, in order for them to redact the thousands and thousands of pages, I think it's an undue burden at this point on the prosecution. I think that maybe what I'm going to do, we're going to have another PCC in a couple of weeks on February the 10th. I think that what I'm going to do is at this moment, I'm going to grant Ms. Shackelford's, and there already is a protective order both in place for Mr. Groom and Mr. Moore. I'm going, so that you can get the discovery forthwith, I'm going to issue the protective order as of today. If there are issues that you have that you feel are in the discovery that you want to discuss with the defendant's parents, we can talk about that on February 10th and carve out an exception if there is one for certain items, certain things, certain discussions. And we can have an off-the-record conversation with the parties at that time if there's something that should be released from that part of the protective order. Do you understand, Ms. Watt? And is that satisfactory to you, Ms. Shackelford? Does that solve your issues too?
Yeah, I think that takes care of it. And Ms. Watt already sent me a hard drive. It's ready to go.
Perfect. Okay, so then I'm gonna grant your motion for the protective order, and then we'll revisit when we have all of the defendants, and the defendants present are waived today. I guess I should have made that clear or had the waivers on the record. Mr. Goldstein, we waive your client's appearance today.
Yes, Your Honor.
Ms. Joseph
Yes, Judge.
and Ms. Watt.
Yes, Your Honor.
With the pandemic, it's a little bit of an issue getting everybody on. And so this was a way to get everybody here today without it, so that we could deal with these issues. The secondary issue is that we have a live date set on February the 22nd, which Ms. Shackelford has indicated, and we had some conversations, Ms. Watt, before you joined us, that she believes that this may run into 3 days. We had it set for the 20th.
Please restart the HBO Max app. Okay.
We had it set for the 22nd and the 23rd. There's some conflicts. It looks like, although everybody's good on the 22nd, the rest of the week is a problem with one or more people. So we were looking at an alternative date, Ms. Watt, in March of the 22nd, the 23rd, and the 25th. So Monday, Tuesday, and if necessary, Thursday. And Ms. Joe, everybody's available as a lock for those dates. And then we can make sure that everybody's got the discovery on the 10th. We'll revisit this, and we may set it even for one more PCC before that to, or some kind of scheduling before that to make sure that everybody's on the same page. Are those dates good for you also, Ms. Watt?
You said March the 22nd, 23rd.
And 25th. So Monday, Tuesday, and Thursday.
22nd, 23rd, and 25th. Yes.
Correct. Perfect. So those 3 days, and because I know it can be complicated getting this many attorneys to acknowledge 3 full days. And so I think we need to take those dates right now and lock it in. With that being said, is there anything else for today? We're gonna have all the defendants on the 10th. And I think it's set at 11 o'clock. And so we can make sure, talk about any discovery issues that are outstanding, make sure everybody's got what they're supposed to have. Mr. Goldstein, my understanding is you're gonna get the drive from Shackelford tomorrow. So
Tomorrow.
you'll have your discovery, Ms. Watt, you'll get with Ms. Shackelford to get your discovery. Ms. Joseph, you're set, you have all your discovery.
Yes.
Okay, so is there anything else for today?
So, just briefly, Judge, so I'm gonna send the court the order.
Yep.
Ms. Watt, as soon as she's orally ordered it, so as soon as we're done, I'll send you the Van Buren and MSP report and the evidence.com link, so you can at least get started, and then we can set up a time to meet for the hard drive. And the only other issue, Your Honor, is I have to comply with the Uniform Act to secure out-of-state witnesses, so I've prepared some documents that I need signature from the court, if I can just email them so that I can get them to a court in Ohio.
Yeah, email them. It may be, Heather's out today, so it may be tomorrow that we process and get them, because I could go up front and have somebody else check her emails, but as it's into the afternoon now. It'll be tomorrow morning. Michelle,
And
Heather's here tomorrow, right? Okay, yeah.
Okay, I'll get those out.
Okay, perfect. So is everybody on the same page?
Yes, and we're starting at 9 a.m. on those 3 days. Each of those 3 days are 8:30.
Yeah, those are live, and I don't know, you guys can call it. It doesn't matter to me, 8:39.
Okay,
We'll revisit it on the 10th.
okay,
Maybe we should make it 8:30. I'll talk to Heather tomorrow about that too. If we make it at 8:30, maybe we can get an increased chance that we get the defendants early, which is going to be what their conversation, because although they're live, we're going to have to incorporate social distancing into my courtroom. So it's going to be a little bit difficult. I don't know, because I'm going to have to live stream this also on Zoom, on YouTube. I don't know the camera angle that we're going to be able to capture everything, especially because what I'm going to do with the defendant and each of their attorneys is probably set them throughout the courtroom, maybe have somebody sitting in the jury box with their client, somebody sitting at counsel table with their client, and somebody sitting in an alternative position with their client, because I don't want everybody on top of everybody.
right.
Obviously, everybody's got to be masked up, and social distance as much as possible, but we'll work around those things. The only people that'll be allowed in the building will be the defendants, their attorney, and the witness, the officer in charge, and the witness that is going to be called.
Okay. Thank you, Your Honor.
Thank you. Anything else today?
No, Your
Nothing
Honor.
further,
No,
Your
All
Your
Honor.
right,
Honor, thank you.
I'll see everybody February 10th. If there is something else, as this proceeds, even between now and the March 22nd date, get a hold of Heather. I'm available all the time, so we can jump on and deal with any issues that come up at any time. Okay?
Thank
Judge, I
you,
have a
Your
funny
Honor.
feeling our biggest problem on those March dates is going to be getting the jail to get our clients.
And that's why I said maybe we ought to schedule it at 8:30. Or even, I'm going to talk to Heather tomorrow. We may even put in, the four attorneys don't have to be here till 8:30. I may have Heather put on the document for the jail to make it like even 8 a.m. Just because the earlier that then hopefully we're at least first, although they may not be, I don't know how many people are going to be transporting. So it may not be an issue, but I would rather put 8 or 8:30 on the transport documentation so that we're not sitting here at 10 or 11. I mean, it's a problem. And I will check and see if there's a possibility for the Monday, Tuesday, at least, if they end up, they used to sometimes, if there were multiple days, not take them back and forth, that they would drop off to the low. Well, I'll check into it to see if there's a way that they can maybe be housed overnight, at least it can't be.
Judge, are spawned, all three of them are spawned. There's a keep separate in the jail. I have another 3 defendant case going on in Inkster, and we've yet to be able to get all 3 defendants in the building at the same time. What we're doing on that case is I actually had the court issue writs from Wayne County Jail to MSP, which allowed troopers to pick up uninvolved troopers, not my OIC, no one like
Yeah,
that,
yeah,
just a
yeah, yeah.
random trooper to actually go and pick up some of the defendants. So we could do writs on 2 and count on Wayne County Jail for 1. And that way we can ensure that all 3
Okay.
are kept separate.
I am going to have Heather reach out to you tomorrow, the logistics on that, to make sure that we can do that on this case, because I was just thinking that if there's, yeah, if there's a separation order, then they're not going to bring them all in the same van.
Yeah, we've been
So-
to Easter multiple times and they'll bring 1, sometimes they'll bring 2. But we've yet to see all 3 of them. So
Okay,
that
so if
was our
that's a,
resolution.
yeah, that's a good resolution. So I'll talk to Heather about that tomorrow, and then we'll figure out a way we can do the same thing. That we do 1 from the jail, a writ, if we do a pickup writ for MSP on 2 of them, and then logistically that should be able to work out.
Okay.
Okay,
Sounds good.
perfect. All right, if you need anything else, let me know, and I think that's it for today, unless anybody has something.
Okay, thank you, Judge.
Nothing further.
Thank
Thank
you,
you.
Your
All right,
Honor.
Ron.
perfect. All right, thank you very